Hi, this is Dr. Cora Stack here. I just wanted to talk about something very serious now because I've been looking at a number of different cases and I'm very good at, I'm pretty hot at observing patterns, but obviously, patterns require a number of different cases to spot them. So this title of this video is Justice Behind Closed Doors, What the Stack, Byrne and Burke cases reveal about Ireland's courts. I mean, this is hugely serious. And these are all unrepresented, this is the point, they're exposing major issues and these are unrepresented, and I think it's a credit to all, that this is happening, that we're raising these concerns about judicial accountability and really the failed system that it represents more than anything else. But that this is international, it's not a national, it's a global issue of access to justice and accountability and fairness. So today we're looking behind the doors of Ireland's justice system at a problem far deeper than any single judge or decision, a problem that cuts to the very foundation of a constitutional democracy. Three very different legal battles, staff versus the state. Now, I'm not saying the state, I'm saying three or four respondents. I'm getting Byrne versus, I think, four respondents, and the Burke litigation reveals something very troubling. And I have to give credit to Mr. Isaac Burke in particular for his brilliance, and Mrs. Martina Burke and Mr. Senior Burke and the others, but in particular Mr. Isaac Burke. I mean, he is a brilliant analyst of judicial. He's brilliant at looking at patterns, absolutely brilliant. So he was the fellow that actually helped me with my bag. Imagine, I think it was him. I thought it was the other one. A pattern of judicial behaviour that cannot be questioned, cannot be reviewed, and cannot be held accountable. And you couldn't. The genius of the design of the Act here is unbelievable. It almost reflects one-to-one the genius of the design, if you want to call it genius, of the amended Protective Disclosures Act. This is the same person designed it. You can see the patterns. Or was largely influential. I mean, there was obviously a number of different people, but the real power behind the thinking, the mind. This is not an attack on the courts. It's a call for transparency, fairness, and the rule of law. Welcome to Justice Behind Closed Doors. So, in 2019, I'm very interested in this sort of thing, examining acts. Ireland, especially the interesting ones, Ireland introduced the Judicial Council Act, a law that promised, like the Protective Disclosure 2002 Act, modern oversight, public trust and accountability for judicial conduct. But there's a problem. The system it created is not independent, it's not transparent allegedly, and not capable of driving real accountability alleged. Why? Because judges investigate other judges. If you look at the Act, panels are dominated by judges. Judicial reasoning cannot be examined. Procedural fairness is off limits, and even if misconduct is proven, the litigant receives no remedy. So what happens when a judge predetermines a case? In other words, it's scripted, it's all done beforehand, issues a judgment that ignores oral submissions, uses disproportionate contempt powers, shows signs of bias or hostility, restricts hearings, or shuts down oral judgment because another thing has been kind of stitched up in advance, allegedly, or. So that's why the oral judgments, the oral arguments would have to be, like our oral arguments were completely excluded. So doesn't split into restricts hearing or shuts down oral argument. All our arguments weren't included in the final judgment, and they were very significant. I mean, I spent a lot of time talking about the balance of convenience, huge issue in terms of deciding, what to do in these kind of situations. There was no word about the balance of convenience, and I've written a huge paper about it. There was no word about it in the judgment. So but it didn't appear in the actual, in the written submission. But it was a huge part of it, the balance of convenience, and I've written a huge paper about it. It's a hugely important issue in terms of making decisions about these kind of issues. And it's a fascinating concept in law, the balance of convenience. Under the 2019 Act, the answer is simple: there is no pathway for redress. Three cases. One systemic pattern. These cases involve different people, different issues, and different courts. Yet they appear to share the same structural symptoms. This is very much what I've noticed in the pattern. Circular, self-protective reasoning. Decisions that seemed predetermined, compressed or restricted hearings. These were made very clear now by the Burkes, and also in my case and in other cases. Compressed or restricted hearings, severe or escalating contempt sanctions. This was very clear from yesterday's very honest views by the Burkes on their station. Judicial commentary that appears hostile or extraneous, striking similarities in judgment across unrelated cases, as if there was someone behind the scenes writing the scripts or influencing what was written behind the scripts in an undue way that would suggest conflict of interest. When different litigants in different contexts experience the same patterns, we are no longer looking at coincidence. We are looking at systemic issues, allegedly. A systemic issue. The Burkes family's beliefs and actions have been polarising. We all know that. But the principle here is simple. The rule of law must apply regardless of who stands before the court. In this litigation, several concerns arise. Judgments that appear pre-drafted. Now, who's doing that? Who's pre-drafting the judgments? Some great Byrne behind the scenes, allegedly. Issued rapidly, because they're saying that he's always late. Is he on the phone to, X, Y, and Z, or is he just delayed because he's otherwise, engaged in writing, or quick drafting, structurally identical, barely engaging with submissions, particularly the oral submissions. Well, if there was someone else drafting behind the scenes, he wouldn't really be there for the oral submissions, would he? Allegedly, now, these are very, very serious questions. This raises the question, were the outcomes predetermined? Judicial language that signals bias, phrases such as grotesque, ridiculous, not normal behaviour, or accusation of lying that underpin the dignity and neutrality of the bench. Contempt powers used repeatedly and aggressively. Imprisonment, escalating fines, threatening commitment of family members. Contempt is meant to be coercive, not punitive, but here it appears punitive. So there's a real punitive mind sign behind this person behind the scenes allegedly doing the scripted narrative. Now this is all alleged, but I mean, it's pretty clear to me as a pattern recognition investigator, being a ring theorist expert, rings in particular, exclusion for hearings, removing litigants for challenging judicial comments runs counter to the principle of open justice. Potential disparities between judicial remarks and sworn evidence, these issues, every single one of them, are immune from oversight under the Judicial Council Act. I mean, isn't that ingenious design of an act? That's the problem. The court asserts that a prior decision was correct. It then issues the assertion to refuse any challenge to it. The challenge is declared non-arguable. The litigant is described as vexatious for questioning the system. The rejection of the challenge is defended on the grounds that the early decision was correct because the court says so. This is circular logic, not judicial review. It leaves no room for procedural fairness, meaningful appeal, or scrutiny of judicial conduct. When the system closes ranks, no internal mechanism exists to correct or investigate these patterns. A possible unseen force, institutional pressure. Across the Stack, Byrne and Burke cases, there is an unusual similarity in judicial reasoning, and told that I have to give credit now to Mr. Isaac Burke, and Mrs. Martina Burke as well, and others in the Burke family for perhaps not realising that these patterns were symptomatic of what I had been studying, but I just needed the evidence of the Burkes, which I believe the Burkes are telling the truth here, but they may not realise there's a pattern here going on in these cases, and we can't be just three. There has to be more of us in it. But I'm able to highlight patterns. I know a bit more that I can't. I know a little bit more than than what I can express openly. But I can see the patterns very clearly now. This suggests the possibility of informal guidance from superior courts, template or model reasoning, institutional protectionism, or a cultural reluctance to allow scrutiny of judicial behaviour. I mean, that's really arrogance and narcissistic defence. None of this requires conspiracy. Courts are institutions, and institutions protect themselves. I mean, that's well known. But judicial independence must never become independence from accountability. That's why on my X I talk about I'm for accountability and transparency. Well, here we are. I couldn't have a better act to sort of tackle it, or to examine the lack of it, allegedly. Under the Judicial Council Act, allegedly, judicial reasoning cannot be reviewed. Oh, that's brilliant. That's brilliant design. Judicial judges investigate judges, a built-in conflict of interest. Brilliant design. And accountability and transparency. Complaints must be filed within 3 months, even if evidence emerges later. You see, that's it. You see, you can't figure it out, and then when it's too late, you're barred. You're statute barred. Proceedings are confidential. No remedy exists for litigants, and removal of a judge requires political intervention, which almost never happens. That's impossible. So it is not the system it's failing, it's that the system is designed to fail. So it's the same thing, designed, beginning with D, by design, by legislative error. To rebuild public trust, the following reforms are essential. An independent oversight body, majority lay membership, independent investigators. You know, the ones that work for the IB and the fraud squad. Expansion of what counts as misconduct, including predetermination, undue influence, disproportionate contempt, and failure to consider evidence. A pathway for litigants to obtain remedy when judicial conduct affects the case. Removal of a judge's consent for informal resolution. Extended time limits for complaints, mandatory public reporting of complaint outcomes, a transparent independent process for removal of judges separate from particular. Accountability is not a threat to judicial independence. Justice must be seen to be done. The Stack, Byrne and Burke cases do not expose 3 isolated problems. No, certainly not. Together they reveal a judiciary that is insulated from scrutiny, protected from accountability, and operating on a framework that favours institutional preservation over public confidence. Ireland stands at a crossroads. Will we allow justice to remain behind closed doors, or will we demand a system that's independently accountable, transparent, and worthy of the trust placed in it? The answer affects every citizen, today and for generations to come. Thank you for watching. If you believe Ireland deserves a justice system that is fair, transparent, and accountability, share this video, shine a light where silence has lasted for far too long. Now, my approach here is that we need a completely new, different system of justice. We need a trauma-led, trauma-informed arbitration first system, rather than this black and white win-or-lose system, because I don't think, all of these, these are obviously transparency accounts, but I think we need a complete shift in our justice system to a more trauma-informed, arbitration-led system of justice, which is affordable and accessible, and that it shouldn't be the likes of lay litigants that are highlighting flaws in a system which is designed to fail the vast majority of people who cannot afford access to justice and are given time, led down the garden path, and then they fail, not because their cases are wrong, but because they don't have they're not in the club of the legal solicitors, being a solicitor. So it's very clear here that this is a very good case for suggesting that a new system of justice is needed, and that rather than focusing on what's going wrong here, I think we need to focus on how to make things right. And I'm suggesting in many of my legal papers, which are getting a lot of attention, access to justice and trauma-informed arbitration worldwide, that there's an urgent crisis in access to justice, and that rather than picking on a particular individual, perhaps the judges themselves here realise there's a serious problem with access to justice, and they need people like us to come forward and highlight but there are very few of us in it, that have the bravery to say, no, this justice system is not working, not just in Ireland but in the rest of the world. We have to fix ourselves first. And